Okay, is someone in the room right now? Can we tell? Can we see that? Awesome. Hello, nice to see everyone.
Hi.
My name's Jeffrey Smith. I'm an attorney with the Orlando Law Group. I work with wills and estates, not exclusively, but that's a large part of our practice. And we're here today to answer any questions you may have and discuss the process generally going forward. This is my assistant. She's an attorney as well. This is
Erika de Jesus. Nice to be here.
Right. So I guess we'll start out. Steve, is there any way I can see questions or anything?
Absolutely.
Does anyone have any questions before we start out? Do you want us to just, maybe go into some conversation, talk a little about wills and estates? Okay, if not, then feel free to interrupt us. I'm going to try to pay attention to the screen. So as Erika and I are conversating about our wills and estates, we'll keep an eye on the screen. So just go ahead and shoot any questions you have out there, interrupt us, stop us. And then of course, also if you want to wait till the end, that's fine too. Before we sign off, we'll go ahead and have a little, a couple minutes at the end to answer any questions that anyone may have. So to begin, all right, I guess probably the easiest way to go through this is Andrea and I are
Erika.
Awesome. Erika and I are going to kind of go through what a typical consult is like. Erika is going to play the role of the client, and I will go ahead and play the role of the attorney. And here we go. So, hello, Mr. Jesus.
Hello, Mr. Smith. It's so nice to be here. Thank you for having me.
How can we help you today?
Okay, so today I'm here to figure out whether or not I need a will.
Okay. Well, it's my recommendation that everybody over the age of 18 have a will. A will is the document by which it's exactly as what it says it is. It's your last will and testament. It's how you dispose of the or give, deliver, gift the property that you have after you die. There are a few exceptions to what you can give and how you can give that to persons and charities and other entities. Largely, that will depend on if you're married or not. The homestead, if you own a marital home with your spouse and it's homesteaded, that's going to be subject to certain limitations on distribution. Property that is titled, cars, vehicles, certainly we can devise those to individuals, but it has a little bit extra work involved with that. The big thing with distributing property via a will comes into it with financial accounts, banking, checking, savings, money market, 401ks, life insurance policies. Those will all pass according to your beneficiary designation with that entity. So really what you want to do is you want to go to your bank, contact your retirement fund, your plan administrator, contact your life insurance company, and make sure that you have beneficiaries in place so that when you die, those persons receive those documents. That should pass outside of probate. We don't mention those in the will at all. If you're one of those rare clients that insists on mentioning it in the will, just know it's largely going to be ineffective, and whatever your contract states with that financial entity is going to be the document that controls. Okay. And
awesome. Okay. So what happens if I have minor children?
Okay. Well, essentially, what will happen with minor children, that's always a big issue in this matter. Few things. Let's start out with guardianship provisions. Generally, actually speaking, the natural parent is, aside from a few unfortunate circumstances, is always going to be the individual that takes custody control of the child. In the event you happen to be the last surviving parent that passes away, we do recommend that we have some guardianship provisions put in there. Please note, though, too, that guardianship provisions in a will are mainly to show the deceased's intent as to appointing a guardian over a particular child or children. The will is not the document that will affect the control or the guardianship of that child. The individual named is actually going to have to initiate a guardianship action and have a court order designating them as the guardian of that child. Otherwise, if a child is a minor and they inherit whatever it is from whomever, generally the guardian or the parent is responsible for maintaining and keeping that inheritance, managing it for the benefit of the child. And at this point, I want to clarify some terms, minor and child. We typically, as people, whenever you mention the word child, we always think of a minor. Well, it's important to understand we can have children that are adults. So there's a distinction between a child being a minor and a child being an adult. And you need to understand that, when we're using those terms in conversation.
Okay, well, that's good. What would happen if I didn't have a will drafted?
Okay, well, if you die without a will, it's called passing intestate. And essentially what that means is your estate will pass according to the intestate statutes for the state of Florida. Of course, if you die and you're residing in Florida at the time you die. So that's okay. But for those of you out there who have no problem with the government telling you how, when, where, and why your property is going to be distributed, that may be the way to go for you. If not, if you want to have any kind of control over where your property goes when you die, you're going to need to have a will.
Gotcha. So how much property would I need, or how do I know if I need a trust instead of a will?
Okay, sure. Well, a lot of clients I have come in and they want to have a trust. I also have a lot of clients that come in and they want to control their property after they pass. So for instance, I'll have a client come in and this individual will say, I have 4 children. 3 of them are very irresponsible. They're constantly in trouble. They're always having problems. Sometimes there may be substance abuse issues. So what this client wants to do is leave everything to child number 1 to then distribute equally to the other 3 children. That's not how that works. What will happen if he did that scheme is he would leave everything to child number 1. What child number 1 then does with it thereafter is completely up to child number 1, and it's not enforceable. If you want to control your property or its distribution or its management after you pass, that is something that you would put in a trust. So in a revocable living trust, you could then put the distribution scheme, we call who you give your property to and how much. And also you can place conditions on that property. You can, for example, you can give a 5-acre piece of land to your friend John to be used only as a playground or to be used only as hunting property. In that instance, through a trust, you can do that. If you tried putting that language in a will, the land would still go to your friend. However, what that friend does with it thereafter would be completely up to them. Trusts, my first question to a client whenever they bring up trusts is, why do they think they need one? Sometimes it's appropriate, sometimes it's not. It depends on what the client's outcome and what they're attempting to achieve is. Note that there are many, many, many different types of trusts. Living revocable trusts are just one of them that we commonly do with estate planning, but there are many, many different types of trusts that we can get into more detail with, it's a little bit outside the scope of this, but we're happy to discuss those with you if you do come in.
Perfect. And who handles the will itself when I pass?
All right, so when you pass, one of the questions we're going to ask is, who is your personal representative? Personal representative, we do have some, I don't say restrictions, but qualifications probably be more appropriate. A personal representative of a will, or the executor, as may also be known, needs to be at least 18. And they should be a Florida resident. If they're not a Florida resident, then they need to be a blood relative or married to a blood relative. to be able to serve as a personal representative. I also recommend that when you designate someone as a personal representative, that you designate more than one. We commonly ask for 3. In the event some are disqualified or some just flat out don't want to do it. And also, what was I going to say about personal representatives? Okay, blood relatives, they are the individual. Oh, when you designate somebody as a personal representative, have that conversation with them. Let them know they are the person you're designating. You don't want that to be a surprise, because being a personal representative of a will does entail some work. It may entail some expenses. Keep in mind those expenses are can be feedback. They can be reimbursed for those expenses, but it's going to take some time. They're the ones that are going to have to file your will, go through the probate process. No, very, very, very few people can avoid probate entirely. And avoiding probate entirely really is for someone that is completely destitute, meaning that individual has probably less than $500 to their name and no property, and or that person has absolutely no outstanding debts whatsoever. It's very rare to encounter someone in either one of those scenarios that actually has a will. There's this idea to have a will or a trust to avoid probate. It would avoid some assets from the probate process, but it's very difficult to absolutely completely avoid having to do the probate process at all.
Gotcha. Okay. That's a lot to take in.
It is.
So what other documents do you think are important for anyone to have drafted, like regarding their finances or their health care if something were to happen to them?
Okay, well, what we recommend here at the Orlando Law Group, along with your will, it's also when we have the time to talk to you about what we call your healthcare and financial directives. Your healthcare directives, those are your HIPAA release form, your healthcare surrogate form, and HIPAA release, healthcare surrogate, your living will. And then we also throw in there what's called a durable power of attorney. So addressing the first one, durable power of attorney, that's a very, very important document. It's a durable power of attorney because it survives your legal capacity. Note that all powers of attorney are going to terminate upon your death. The difference between a durable power of attorney and other general or special powers of attorneys is that it's durable. It survives your legal incapacitation. So even with a general power of attorney or a special power of attorney, that agent, that person you designate, only has the power to exercise the actions that you would exercise at that time. Well, if you're incapacitated at that time, really under a general or special power of attorney, if you're incapacitated, your agent is incapacitated. Under a durable power of attorney, if you're incapacitated, your agent can still act. And that's important if you find yourself in a coma, if you find yourself for whatever reason incapacitated for days or weeks or months, for individuals that develop mentally challenging conditions such as dementia or Alzheimer's. Understand many mentally compromising conditions come on gradually and they vary in degree. So if a simple diagnosis of Alzheimer's or dementia isn't necessarily going to knock somebody out of being able to sign a legal document, that's going to be a decision that's going to be made at that time of signing. However, if you unfortunately know someone or have that diagnosis, that's a really big red flag to go ahead and get this done now. Get those documents signed, because if they don't, as the disease progresses and the individual spends more and more time in a state of incapacitation or incoherence, they're going to reach a point where they can't sign the documents at all. So that's the importance of a durable power of attorney. So while you're laying there in the hospital, your agent can pay your taxes, pay your bills, make decisions about paying your bills, manage your property, Any, the variables are endless as to each person's specific situation. So that's a very recommended document that we ask that you get, or we recommend that you get. Contrary to the healthcare directives that we are going to talk about soon, but your healthcare directives, we recommend that you copy those and leave a copy or email a copy to all of the medical providers that you see on a regular basis. The durable power of attorney, you want to kind of keep that under wraps, because with a little bit of whiteout and a good copy machine, it has a high probability of fraud. But you should know and let your agent know that if you ever do intend to use or have the need to use a durable power of attorney, that the entity that you're seeking to use it with may require a copy, and that's okay. There's no problem with that. Moving on, our healthcare directives, the HIPAA form, that gives your agent the ability to access your protected healthcare information. Understand, if you've been going to a family doctor for years and years and years and seeing this person, since your birth, oftentimes they're going to talk to your spouse. They know you, they have that relationship, but also understand the medical facility takes that risk that they're going to say something to someone that they shouldn't about your protected healthcare information. The HIPAA really comes into play when you're at a hospital in a surgery condition, for example, and you've never met that surgeon before. They don't know who you are. The people at the hospital don't know you or your relatives. Additionally, another aspect that people often overlook where HIPAA form becomes necessary is dealing with health insurance companies. As your health insurance bills, procedures, paperwork, those all deal in some form or fashion with your protected healthcare information. So you also want to send your HIPAA release form to your insurance company as well, if you haven't already signed one. Next, we have the healthcare surrogate form, and that's a form that allows your agent to make medical decisions for you that do not necessarily involve removing you from life support. So oftentimes, an accident could occur. Your loved one is laying in the hospital, and the doctor may come to you and say, look, there's 3 different procedures that we can do. These are the prognoses for each of those procedures. This is the level of risk. How would you like us to proceed, everything else being equal? That's where you come in as the healthcare agent. The living will, which is the 3rd of our 3 healthcare directives, that is the document that allows the agent to remove the person from life support and pretty much allow them to die naturally. These are very, very important documents, because if someone challenges the hospital or challenges the individual that they have asked to, for permission or to let them remove from life support, if a conflict arises, I'm mainly speaking, the most famous case that I can think of is the Terry Schiavo case, where we have a young lady on life support. The hospital looks to the husband. I believe that's how the case went, and she's not coming back. She's in this sort of medical determined state. You can go ahead and remove her from life support. She did not have a living will. Their parents strongly disagreed. At that point, the hospital's not going to make that decision. They're certainly not going to take that risk and liability. They're going to say, bring me a court order, unless you have the 1 or 2 page living will that you can get done at the same time you're doing your will. If you get a chance, go ahead and Google Terry Schiavo, and you can go step by step on the 15 years that she laid in life support while they fought this through the courts. It's worth its weight in gold when it comes to the slow, smooth transition of managing your healthcare. So we offer those here at the Orlando Law Group. You can get a will individually. We have a simple will. A simple will is a will that we call a will that does not have the guardianship language that we previously spoke of, or testamentary trust language. Testamentary trust language is language that we commonly speak with clients that have very young children, where that client wants to leave their inheritance to their children in bits and pieces at certain ages. So For example, it might not be a good idea to leave an 18-year-old $1 million life insurance policy or $1 million in stocks. So one of the options you do have using the testamentary trust language, and this is customizable to however the client would like to do. We can leave 1/3 at 18, 1/3 at 25, 1/3 at 30, and the combinations are endless. Typically a third, a third, a third, and or 25, 25, 25, 25 is what we commonly see clients leaving to children. Now, of course, during that time, we also have a trustee that's in charge of managing that property for the child. We recommend that the trustee and the guardian not be the same person. Otherwise, that's like the fox garden hen house. And we commonly do put provisions in our testamentary trust language, and I usually include it in my revocable trust language, that the trustee, at the trustee's sole discretion, can provide for the child's health, well-being, and education prior to any distributions. So we don't want to have someone not be able to go to college, or someone need money for some sort of emergency medical situation when they have $1 million sitting there that they can't access. So certainly we leave that little bit of an out there for the trustee to give those distributions directly to the institution, to the hospital, or to the school, for those emergencies or as they may come up. Otherwise, the beneficiary, which is the minor child or the child, actually they're not a minor usually at that time, and they don't have to be minors, just as a matter of practice, because the distribution ages typically start at 18. I've seen them go all the way up to 40. Particular parent, you can make it whatever you want. But that's it protects the inheritance, but it also protects the child as well, so they don't end up blowing all their money when they're at their most intelligent age of 18 to 25. And so that's how that rolls. Do we have any questions from the crowd? Yeah, please, one at a time. Don't knock down our server. Be doing it at once.
I have a few little topics that maybe we can touch on that are most commonly that we encounter whenever we're drafting documents. So what happens usually if you want to change something in your will?
Okay. Well, let's suppose that happens. Let's suppose you come in, you talk to us, and you want to name your brother John as your personal representative. Well, a year later, you have a falling out with John, or for whatever reason, you just change your mind. And you're like, I don't want John to be my personal representative. So we can do what's called a codicil. A codicil is an amendment to a will. Typically, in terms of costs, it's a half or less than half the cost of actually drafting an entire new will. And we simply change that one provision. So you come in, you let us know what we want to change, and we can switch out John for just about whomever you want to put in his place. Now, keep in mind, we really do need to review your existing will with the changes you want to make, even though they may seem small and simple. We have to make sure the document flows and that there are no contradictory provisions. So sometimes making a small change could flow through the entirety of the document, which may knock it out of the codicil range where we may have to draft an entire new document. Sometimes we may not. That's a conversation you'll have with your attorney. Okay, so we see we have a question. Hi, Wilda Pomales. How are you? Okay. If a property is out of the country, do I still include in my Florida will, or will I need to do a will in that country? Very good question. Thank you for bringing that up. Number one, yes, I would absolutely include that property in your will. However, understand that what will actually happen in practice is you'll have to open what's called an ancillary probate in that other country or in that other state, for those of you that may have properties outside the state of Florida, and you will present this will as evidence of how you want that property distributed. Basically, it's because Florida does not have jurisdiction beyond the state lines of Florida. And although Florida can enter orders affecting property outside the state of Florida, orders are useless unless they can be enforced. So you can certainly get an order distributing property located in another state or country from Florida, but then you also have to go to that state or country. In this instance, it would be an ancillary probate to actually enforce that order and transfer that property. Now here's another, I don't want to get outside the topic here, but something to consider is how do you want that property to be transferred? Reason being is in Florida anyway, and this is for, if there's anybody watching that's from out of state of Florida, we can very often transfer property outside of the probate process without involving any probate or wills or anything of that nature. There's two ways, just thinking off the top of my head how to do that. One is to retitle the property as joint tenants with rights of survivorship with the individual that you want to have that property when you pass. The pitfall to doing that is that individual will have immediate ownership interest in that property. Most people don't want to do that, but you know, there are certain situations out there where that may be feasible or that may be attractive to somebody that wants to do that. The other way to transfer property, and again, we're not getting into homestead property here, but if this is just non-homestead property, what we can do is what's called a ladybird deed, a enhanced life estate deed. And essentially what an enhanced life estate deed is a way for you to transfer your property to a beneficiary immediately upon your death. And that beneficiary has no ownership interest in your property until your death. And it happens as a matter of law. You don't even need to file another deed. It just, the moment you die, boom, property ownership is transferred. You're done. No will, no nothing. Don't need to involve probate. And just understand too, if this is something you're interested in, an enhanced life estate deed is different than a regular life estate deed. A regular life estate deed grants a life estate to that person to live on the property. However, the beneficiaries do incur some financial responsibility. It's a little outside the scope of estate planning, although it can be done. So just be sure if this is pursuant to a will or some sort of estate planning where you just want to give property to somebody when you die, make sure you use ladybird deed or enhanced life estate deed. And the reason I brought this up, Wilda, is because perhaps the property that you're or the country that your property is located in, or for those of you who are watching, if you have property out of state, check that jurisdiction's rules and statutes, and perhaps they have something similar that Florida has. And that way, at that point, you know, if that country or that state you are able to retitle your property somehow to keep it out of probate, you won't have to mess with it at all. It'll just happen automatically upon your death, the transfer to the beneficiary.
I think you answered that question beautifully. Another issue we tend to have with consults and just in general when we're drafting is whether or not a client has, we have another question, whether or not a client has stepchildren. So we like to find out whether or not you do have stepchildren from another marriage, from the current marriage that you're in, because if you don't include them in the distribution or the beneficiary list, they will not take. So I don't know if you want to expand on that a little more.
Well, you're pretty knowledgeable for a client.
I am.
Okay. Can you who is this? Karen, can you add handwritten requests or changes to the will in lieu of the codicil to save costs as long as it is witnessed and notarized? Well, here's the problem is maybe. If you essentially what you're asking, whether it's handwritten or not, that's okay. What essentially you're putting up here is, can you do your own codicil? So I imagine you can. The issue comes up in the technicalities. That's oftentimes where we have issues with clients that draft their own paperwork, their own documents. I know we had a case not long ago, about a year, maybe 2 years ago. The deceased wrote a great will. It was 2 to 3 pages long, very detailed, handwritten, and he signed the bottom of it. He dated it. The problem was there were no witnesses. And that unfortunately, that individual's estate went testate. So and just like with your question here, as long as it's witnessed and notarized, codicils have to be drafted with the same formalities as a will. But believe it or not, wills do not have to be notarized in Florida. They do have to have 2 witnesses. If you have 1 witness, gets knocked out. So that's where I found that clients tend to stumble unknowingly, is not necessarily in communicating their intent and what they want to do, but it's not executed properly. All sorts of issues come up. Now, we do, as a courtesy to the client, have what's called a specific bequest form, and we include this form as the last page of each will. And essentially, depending on the type of property it is, of course, suppose the client wants to leave their golf clubs to their friend Dave. All the client would need to do is go to that last page, write in their golf clubs. I recommend describing them as specifically as possible, by brand, by number, the color of the bag, maybe even include a picture. And then write in that line who they want to give it to and their relationship to that individual. Maybe include some contact information such as an address, phone number, email. Sign it, date it, and put it back with your will. That's called a specific bequest. And specific bequests are appropriate for most tangible property. Of course, that would not be appropriate for accounts, financial accounts, or any titled property. That would not necessarily, I imagine you may be able to transfer some title property that way as an intent, but it would still have to go through the probate process, and it would also depend on how that object or property is titled. My recommendation on the specific bequest form that we provide at the end of the will is, under the statute, you do only need to sign and date it, and that's perfectly fine. But what I do recommend is that you take the extra step and get it notarized, because one of the challenges that will come up is that's not mom's signature. And without a notary on there, now we've got to fight that. And the whole part of this process is to avoid court time, to avoid litigation, to resolve disputes. So while it's not required to be notarized, I would recommend it in that instance to simply do away with any of those arguments. Additionally, if at some later date you decide, hey, I gave my friend John my golf clubs, now it's 2 years later, I want to give my friend Bob my tennis rackets. Use a different sheet of paper, sign it, use a different date, and do the same process. Don't just add it to the same piece of paper that's already been signed, dated, and hopefully notarized in that respect. You're not supposed to modify any documents that have already been notarized. And also, if you just continuously add it to the same sheet of paper that was dated the first time you used it, an issue of fraud could come up in the event that the item that you're giving to someone was purchased after that document was signed. Then it's like, well, how can I devise somebody to somebody in 2020 when I put it on this list in 2018? I wasn't even the owner. So that's why you want to continuously use pages after pages. Just stick it with your will, and that's perfectly fine. The other thing too, it might touch on your question a little bit. I've been getting the question from clients in, how do I tell my personal representative where to go? Or if something changes, how do I tell them what accounts to look for or what bank? There's nothing that stops anybody from just writing a letter, stating where your bank accounts are, maybe put the last 4 on there, put contact information. If you have a financial planner that has your retirement, maybe your life insurance, put their information, put their business card in there. If there's an attorney that you're already working with, put their card in there. Leave any kind of messages that you want on your will, so that when the individual finds it, that they have a better idea of where to go. You can change that very easily. Just keep it updated, and it really goes a long way in having everything sorted out when your family is going through an emotional event, such as one where you pass. The other thing I tell clients as kind of a practice tip is talk to your kids, talk to your beneficiaries, let them know who's getting what up front. They don't like it, who cares? You'll be dead. But it goes a long way in preventing a lot of disputes. The other thing I want to touch on too is where you're going to store your documents. Now, understand most of us don't live with our children. If you're with a spouse, that's great. They'll know where it is, or they should. But when you're the last survivor, or if you're someone that just doesn't have anyone living with you, you need to, how do I say this? You don't have to give your personal representative the combination to your safe that you keep your will in, but let them know where to find the combination in your house. Because there are many people out there that write wills, they spend this time and money on an attorney, they go through this process, but if the personal representative can't find your estate planning documents, they are of no use in effect. So, like I said, but let them know where it is, where to get it. If it's in your sock drawer, tell them it's in your sock drawer. If it's in a safe, you don't have to give them the combination, but give them tell them where the combination is in your house. The one thing I do discourage often is safe deposit boxes. Depending on your financial institution, many safe deposit boxes require 2 keys from 2 individuals. And if one of those individuals is deceased, you're right back to square one to get a court order to open the box on behalf of that individual, and that kind of defeats the whole purpose. So plus, where's the key? Finding keys. It's hard enough to find documents, let alone finding a key that someone may have had. So I discourage safe deposit boxes. However, you're free to protect it and store it as you wish. But like I said, let them know where it is, how to access it, at least generally tell them what room it's in. It'll save a lot of time and aggravation in going through your stuff when you pass. Do we have another question there?
Looks like there's a little notification. It might just be the same one. Oh, here we
Okay.
go.
All right. Hi, Karen. Pre-planning for end of life is important as well. Disposition of remains of dead funeral survey, which I'm doing since my and the tough decisions. You are right.
Yep.
Generally, on our wills, we make a very general statement that upon your death, your remains are to be disposed of. Usually, we include either burial or cremation, whichever you prefer. Otherwise, the language I use is at the personal representative's discretion. Not to get too morbid, but depending on your personal situation, understand, and I would have to go back and research the statute on this, but having dealt with it a year or 2 ago, I learned that an individual has to be buried, cremated, or embalmed. I believe it's within 48 hours or 72 hours of death. This is going to add somewhere around $700 to $1,000 to the cost of those funeral expenses. So depending on your particular family scenario, if you're not going to have a wake, if you're not going to have a viewing, you can save yourself quite a bit of money, and the estate of that individual quite a bit of money. If you're not waiting on people to be flown in, or if you're not waiting to do a viewing or a wake or anything of that nature, go ahead and have it done as soon as you can. And there's, if they can have their remains lawfully disposed of within the required time of the statute, you can save yourself the expense of embalming, cremation, or burial. As that does have to be done. And I want to say it's just within 48 or 72 hours of death.
Gotcha. I think the last question I have is, what if I have a will from another state?
Florida honors foreign wills so long as those wills were drafted and executed according to the laws of the state or country it is coming from. So there's no problem. Florida would certainly honor it, but as you know, as we touched on throughout this this webinar, Florida has at least two of the requirements of a Florida wills. One, it's got to be signed. Two, it has to have two witnesses. Whatever some other state or some other country, whatever their rules and statutes are for the validity of their estate planning documents, as long as the document appears on its face to have been drafted and completed in accordance with those formalities, then Florida should honor it as well. Keeping in mind, Florida would not have any, they could issue the court can issue an order of distribution, but they wouldn't order, they couldn't control an order to distribute land or property outside the state of Florida. You would have to do what's called an ancillary probate after the probate here in Florida has been done. And just a little tidbit, you are supposed to file your probate in the county in which you resided in at the time you die within 10 days of death. Very few people ever get it done within 10 days. I don't know that anything really happens to you if you don't. But the proper court, the proper venue for your probate is with the probate division of the court when you resided in at the time you died. And that's whether your will is in Florida or you're just living in Florida when you die and you have a foreign will.
Well, those are all my questions. I'm sold.
Awesome. Anybody else out there? Last chance before our beautiful faces head out and go to lunch. Anything?
Anything in the chat?
Oh.
See anything in the Q&A? I think that's it.
All right. Thank you for listening. If you have any further questions, feel free to call or email us, and hopefully we can help you out.
Definitely.
Thank you very much. Have a good day.
Bye.